Welcome, everyone. Thank you so much for joining again. If you've joined us in previous sessions, if this is your first one, thank you for joining. We have really a wonderful group of participants today to talk about a very dire situation that our United States Supreme Court has put us in, trying to block affirmative action, which will have deep impact on the minority communities that we love and work for. This is a timely and relevant issue on campuses of higher education across the country and in all endeavors seeking uplift for underserved communities. We've assembled a great panel. Each has a perspective to contribute to the discussion. Our first panelist is Dr. David Carlisle, our president at CDU. He is the longest serving and most successful expander of programs and fundraising in the university's history. This year we opened our first full 4-year medical school in the history of the school, so we're just elated about that. He's a graduate of Wesleyan University, and has a medical degree from Brown University and an MPH from UCLA. He is a tenured professor at UCLA and has served as director of the Office of Statewide Health Planning under 3 governors, Gray Davis, Jerry Brown, and Arnold Schwarzenegger. The third panelist, no, that was our first panelist. Our third panelist is Thomas Saenz, who is just an amazing lawyer and just the most humble human being for the wonderful things that he's done in his career as a lawyer. He is the head of MALDEF, and he's a summa cum laude graduate of Yale undergraduate school and a graduate of Yale School of Law. And he clerked for a liberal Ninth Circuit Judge Stephen Reinhardt, and he's just been a force for good and for achievement in MALDEF for years and years now. He joined them quite a while ago, and he's been steadfast in leading them in fighting all sorts of negative legislation, targeting particularly undocumented Mexican Americans and other Central and South American residents of Los Angeles. Let's get started with our questions. Thank you all for being here. Our first question, John Patton, Attorney Patton, what changes, if any, do you anticipate in workplace diversity efforts and employer practices in light of the Supreme Court's decision? First, say a word about what the Supreme Court decision is, please, because people may not all know about it.
Well, yes, I'm happy to do that, Sylvia. Thank you. The decision was greatly anticipated, and as you mentioned, the consequences of it are reverberating and expanding and causing great unrest in so many places. However, ironically, the holding of the cases before the Supreme Court are breathtakingly narrow. The private university that was sued by students for fair admission was Harvard University, and the public university that was sued was the University of North Carolina. These are 2 universities that are considered highly selective. That is to say, many people are qualified to go to their universities, but at any point in time, there are very few seats. And so the selection process comes into play. And the only question before the Supreme Court regarding those 2 universities had to do with their admissions process, nothing else in the university. And the only question about the admissions process, whether each of those universities, which considered race as a factor, not as a sole factor, but as a factor in making the admissions decision, violated the Equal Protection Clause of the 14th Amendment. there's an irony here. The same decision that they've rendered in this case in 2023 was rendered in the opposite direction by the Supreme Court in 2003 in a case called Grittinger versus, in a case called Bowling. And who was the plaintiff in the case?
I think it was Grutter versus Bollinger.
Grutter versus Bowling. The other case was Gratz. Those are two cases that involve the University of Michigan. And as a result of those two decisions 20 years ago, the processes that the two universities under consideration in this case fully complied with what the Supreme Court said 20 years ago. And this is the part that's a little scary for the Supreme Court to reverse itself so quickly and seemingly only based on who's sitting in the seats. I'll be a little dramatic. It's destabilizing to democracy when that can happen. The precedent that the court should provide in any decision process is now completely undercut. So that's what the Supreme Court decided, that they could not take race into consideration in their admissions decision. And there are many other things that people are talking about that are not part of the holding of the case. So I'll leave it there, Sylvia, and go on to say, now, having said that the decisions are narrow in their holding, the consequences are broad. People are talking about what's going to happen in the employment area. People are talking about what's going to happen in matters of financial aid, none of which was in front of the Supreme Court in these decisions. But the other shoes that are going to fall have to do with all the other places where affirmative action is used as a means of achieving diversity in so many areas. And
so
all of that.
So it soils the water for us.
Yeah, it does. It does.
And just to put it in lay terms, Mr. Saenz, you briefed cases on affirmative action before the Supreme Court. How much of this ruling is going to be subject to misinterpretation? John is trying to tell us what it does say, but are we going to misinterpret it out in the broader audience?
Thanks, Sylvia, and it's a pleasure to be with you on this unpleasant subject.
Yeah.
And the answer to your question is absolutely. We've already seen misinterpretation of this decision. There are some who will overread it intentionally because it is consistent with their long-term policy aims. And there are others who will unfortunately misinterpret it mistakenly, but we have to guard against that. I want to begin by noting that here in California, we are familiar with this phenomenon of people over-interpreting, over-applying bans on affirmative action. And that is because, as you know, in California, at least with respect to our public colleges and universities, Proposition 209, way back in 1996, barred the use of race in making admissions decisions to public universities and colleges. So that, first of all, means that this decision should have no effect whatsoever on our public universities and colleges in California. It will have an effect on private universities and colleges that were not affected by Proposition 209 over a quarter century ago. But we have plenty that we've learned in California after Proposition 209. There were a number of years where folks misinterpreted Prop 209 as somehow meaning you could not talk about race. You could not talk about racial disparity if you were part of the governing body for a university, or because Prop 209 swept more broadly, any part of government. And that really prevented California from reacting effectively to the harm that would be done by Proposition 209 for a number of years. So I think it's very important first to counter that potential misinterpretation. Despite what the Supreme Court majority decided, it was not a mandate or invitation to ignore race or ignore significant racial disparities. Indeed, Chief Justice Roberts, in writing the opinion for the majority, clarified that the decision did not prevent any applicant for admission to any university, including Harvard or UNC, in the country from talking about how race or their experiences with racial discrimination may have shaped them as an applicant for admission. Now, that's important because it means that universities can consider on an individual basis, not a systemic basis, as had been allowed previously, but may still consider on an individual applicant basis issues of race and racial discrimination if, for example, they are raised in an applicant's essay submitted for admission. That also means more broadly that this is not an indication by the Supreme Court that we should ignore race or racial disparities, the result of continuing racial discrimination in higher education or anywhere else. Indeed, there remain on the books legal obligations coupled with very strong moral obligations for universities and other entities to more carefully look at racial disparities that may apply to the criteria they use for admissions. So I think that's the first misinterpretation. There are going to be folks out there saying, ooh, you can't talk about race. Ooh, you can't talk about racial disparity. What are you doing? Pointing out that there's a disparity between the percentage of Black or Latino students in high school and the percentage who are being admitted to this university. You absolutely can talk about that, and we should be talking about it and expecting our policymakers to incorporate an analysis of what causes those disparities into how they shape future policies. Now, the second misinterpretation that we have to guard against, and Mr. Patton has already discussed this, that is that this case absolutely says nothing about affirmative action in employment or affirmative action in contracting. Has nothing to do with this case. Indeed, the Supreme Court long ago devised very different tests for affirmative action in employment, affirmative action in contracting, and then affirmative action in university admissions. Indeed, in some ways, it was always much more difficult to engage in affirmative action in employment or contracting in comparison to university admissions. So we have to guard against the misinterpretation that somehow this case means the end of affirmative action in any setting. That is not what the court decided. It is, however, true. As you said, muddying the waters, this decision has emboldened some of the very well-financed folks who have made it their mission to try to root out any efforts to eliminate the effects of racial discrimination. So they're trying to use this decision already in contexts where it doesn't apply. We've seen law firms sued about their affirmative action pipeline programs. We've seen a foundation sue about its desire to direct funding, particularly to organizations led by Black women. We have seen a lawsuit against government for, in the middle of the pandemic, seeking to ensure that those entities led by people of color were receiving their fair share of what was being distributed by government. None of those contexts have anything to do with the Harvard or the UNC case. So we are going to see this, if you will, revivified effort in all areas to eliminate affirmative action, and we need to be prepared for that.
Dr. Carlisle, could you give us an idea of the ethnic and racial composition of Charles R. Drew University at this time? What is the picture of diversity at the university, and will that diversity excite people who interpret this decision the wrong way to come at the university and say, you're doing it wrong and you're harming my ability to get in as a person who doesn't belong to one of those groups? Can you talk about that?
Yes, and thank you, Sylvia, for your great introduction. Thank you for that question. And that's a complex question with multiple parts. And maybe I'll just take one of them. kind of head on, because people are surprised when I say this. Charles R. Drew University of Medicine and Science does not use racial and ethnic preferences or affirmative action in our admissions policies, except as defined by our mission. And our mission is to serve people from South Los Angeles. Despite that, we have maintained our status as the second most diverse private four-year university in the country in terms of both student diversity and faculty diversity. We have by far the highest percentage of African-American enrollment of any university in the state of California. And our new medical school, all by itself with 60 students, just increased the number of African-American students entering medical school compared to 2021 numbers by almost 15%. This is a school that has the word diversity in our mission statement. It has the word diversity in our values. We are proud of the fact that we are diverse. But in answer to your question, I'm sure that some people will very much try to target us because of our diversity. I think that we can't ignore that that possibility. You'll recall, Sylvia, at the university 2 years ago experienced some bomb threats. We don't know exactly what the motivations were behind the person who was identified for initiating those, but we are a target. CDU is a target because we celebrate diversity. And not only do we celebrate it, but we also achieve it. We talk the walk and we walk the walk.
Thank you for your description of what is happening and the progress that the CDU is making. But it doesn't mean that we don't have naysayers out there. And Mr. Patton, are there potential implications in this ruling on CDU's accreditation process or funding sources that emphasize diversity and inclusivity?
Certainly. And what Thomas mentioned is part of, and I'd like to be honest, I'd like to say people are misunderstanding what happened, but I'm not sure everybody's misunderstanding what happened. There are people who consider this Supreme Court ruling as another arrow in their quiver to accomplish just what Thomas mentioned. Diversity, equity, and inclusion have become buzzwords, and they have nothing to do with the Supreme Court decision. Diversity is not a bad word. Diversity is not illegal. As a matter of fact, this university, Charles Drew University, receives federal funding for promoting diversity. So it's hard for me to imagine that by doing so, we have been violating California law for all these years. As Thomas mentioned, the California, and there are 10 states in the United States that already had ruled against certain forms of affirmative action. We've been under a more stringent requirement as a private university receiving government funds. That's how they got us on Prop 209 since 1996. So our life hasn't been significantly altered except in one aspect. People are going to be looking at our university, thinking they see something that isn't there, and they're going to be trying to do things to us. I think it was last week, it was just recently, 10 United States senators wrote to a number of universities across the country and said, stop doing what you're doing to promote diversity. That's illegal since the Supreme Court decision. And the Supreme Court did not rule on diversity per se. What they said was you cannot use race, and it isn't even, just like what Thomas said, it's not that you can't use it at all. It can't be your sole decision to select one person over another person based on their race. CDU's never done that. We haven't done that the whole time we've been here. So that isn't something that disturbs us. However, we do receive funds. We receive funds from private donors who give us money for certain purposes. And so trying to unpeel this as to where it's going, how these other shoes are going to fall, is not necessarily looking at it from the standpoint of what the Supreme Court decided, but where the expansions of the decision are likely to lead. This case that we're talking about had nothing to do with the money that you might receive from people for scholarships, for example. And a private person can give us money and say, I want to promote and I want to give scholarships to some person or some group of people based on what, in my mind, is not illegal and is a good moral thing to do. And if they told us they wanted us to have money for Black male doctors going to our university and scholarships to be provided for that purpose, the Supreme Court hasn't ruled on that.
Dr. Carlisle, let me ask you to help us clarify admission of students and decisions about financial aid and scholarships. Are those 2 or 3 different buckets? Are we getting those buckets confused? Can you help us understand? Because I think it's hard to keep it clear what's not involved in what the Supreme Court talked about, that we've been doing, and that what we've been doing has been working to give us this kind of diverse population. Can you talk about that?
Yeah, I'll defer to the 3 attorneys on this call to answer the latter part of that question in terms of the Supreme Court's position on say financial aid. Since I'm not a lawyer, but I will say we decouple, as most schools do. There's no connection between admissions and financial aid at CDU. That's true at most schools, quite frankly. They base their financial aid decisions independently. They make them independently of the admissions decision, and we certainly do that as well.
All right. Well,
Sylvia, can I
yes, Tom.
I want to emphasize something that Dr. Carlisle said earlier, and that's I want everyone to understand that issues do not have a race. Only people, individual people have a race,
Point.
which is to say, if you're going to give financial aid or a scholarship to someone who has a demonstrated commitment to serving the population in South Los Angeles, even though we know the population of South Los Angeles is Black and brown, that is not race-based scholarship. That is a scholarship that's based on an issue, a demonstrated commitment to serve a particular population. That is perfectly legitimate, will remain legitimate regardless of how the Supreme Court or other federal and state judges may read the Harvard and UNC decision. It will always be legitimate to award a scholarship based on a particular focus, a particular issue. It's different from saying that scholarship must go to a person of a particular race. If you say the scholarship must go to someone who has demonstrated a commitment once they become a doctor, for example, to practice in South Los Angeles, absolutely legitimate. Nothing whatsoever wrong with that. And that's true even if we come to find that the vast majority of those who have such a demonstrated commitment to serve South LA are Black or brown. And there's nothing wrong with that. That scholarship is not at all in danger because it is not a race-based scholarship.
So, John, should we stop using the term affirmative action? Is that has the result of this decision made it just a word that brings up things that are not barriers, that Tom is talking about, are not barriers, but are being interpreted by the public at large as barriers to the kind of work that we and other organizations are doing to benefit poor communities, which are disproportionately Black and brown?
I want to challenge a little bit of the premise, but I want to answer your question directly. That's a fascinating question. I don't think the community at large is having these problems. I think that well-funded and ideologically extreme forces are having the biggest problem. I would imagine, and I don't have research to back this up, that a vast majority of people think that things like diversity, things like inclusion, are very valuable and laudable things. And it's the minority of people who say that something bad is happening when that occurs. Now, let me go back to the other question. So the use of words. I've got to tell you that you've asked a question and maybe you don't know that you asked it. It's about our courage. We were created to do what we do. And the question is going to be whether bullies are going to prevent us from saying what we're doing, even though, as Thomas mentioned, what we're doing is perfectly legal. But yes, if you have diversity in a policy in your university and somebody finds it, somebody's going to decide that they need to take you on. Our university was one of over 150 universities after the decision who received letters from an organization related to the plaintiffs in the two cases saying, aha, now that this decision has been rendered, we expect all of you to confirm that you've stopped all your diversity programs because now they're illegal. Of course, we ignored that letter because that's a misinformed person who doesn't know how to read cases and doesn't understand the state of the law. So we didn't feed into that by responding. However, yes, if you're asking whether people are going to decide that these are places where they can become almost private attorneys general to enforce what they think the law is, we already know that's happening. Thomas already mentioned some of the cases. There's a high school in Virginia that also got sued because they have diversity programs. There's nothing that they were doing that was illegal, but they were a target. And we probably will be among many, many, many other targets because in academia, there are a few things that have been established that are clear. And one is that diversity of viewpoints, diversity of people, diversity of thought, diversity of experience promotes the educational outcome.
Well, Tom, you have been engaged not with people who we would consider our adversaries. You've been engaged with people who've been friendly to our point of view and our efforts to uplift in our communities. And yet you've had battle royals with, our liberal Democratic governors and you've had to fight them down. Are we going to have a situation where leadership is not going to be talking about this in the way the three of you are, but is going to be talking about this in a more nervous, let's not do so much of that anymore frame of mind?
I think that's a legitimate fear. I think we have a lot to do to just make sure folks understand what affirmative action is in its many different aspects. Race-conscious admissions is only one element of affirmative action. Affirmative action really means taking affirmative steps to address discrimination and its continuing effects on particular populations. That means that any good government is engaging in affirmative action because it recognizes that the perverse effects of discrimination actually drag down economies, they drag down societies, they do not promote thriving. So we have to ensure that all of our leaders are voicing a commitment to affirmative action in that sense, a recognition, often really ignored by too many, including on the Supreme Court, but a recognition that racial discrimination still occurs and it still has dramatic effects because it is embedded in our systems. For example, many of the criteria that are typically used to make admissions decisions to universities have discrimination embedded within them. I mean, one that we're hearing about in the aftermath of this decision are legacy preferences, which a number of highly selective, particularly private, but even some public universities engage in, which is giving extra consideration, extra weight to the fact that an applicant's parent or grandparent attended that university. Well, that on its face has a demonstrable discriminatory effect in favor of white applicants. And that can no longer be tolerated. I think legacy preferences are probably dead in about 5 years. But there are other criteria. Standardized tests now being questioned by many institutions, including the University of California, of course. But standardized tests, even at graduate admission, have serious questions around them. But I want folks to consider that even beyond the standardized tests, we have to look at the criteria we use. One of the great achievements of the Black Lives Matter movement was to create greater awareness that many police officers have subconscious bias based on stereotype in their heads as they go about doing their work. Well, that is not limited to police officers. We have educators who have subconscious bias that is dictated by stereotypes that work, frankly, against Black and brown populations in the education arena in favor of white and Asian populations in the education arena. But we have educators, principals, teachers, counselors, and then we rely on those folks who have those subconscious biases because they're human. We rely on them to write letters of recommendation, right? Whether it's a principal, a counselor, teacher, and we consider those letters without taking into account the likelihood of some subconscious bias playing out. We take those letters and consider them in deciding who, quote unquote, merits admission to a university. So we have to begin the deep and very arduous work of looking carefully at all of the accepted criteria that have been around for decades and decades, and see how and whether we can use modern tools to root out the discrimination that's built into them. In some cases, it means we have to eliminate them as criteria. That's legacy status, that's standardized tests in mind. In other cases, we have to look at ways to make them better. Ensuring, for example, using the most modern thinking. We're in the era of AI after all, but using the best procedures available, we've got to find a way to root out the subconscious bias that may affect what letters of recommendation look like. And I want to emphasize again, that's not just a moral obligation. That is a continuing legal obligation for every university that receives federal funding. And I believe that's every university in the country except one. So there is still in federal regulation an obligation to remove, address discriminatory effects, regardless of what their intent was, discriminatory effects, significant discriminatory effects in our criteria of admission.
Wonderful. Dr. Carlisle, you sit at the table of many important policy makers. They will not have the opportunity to hear the discussion that we've been having this morning on how not to be stymied in what has been the effort so far to be more inclusive. Do you think those venues, I know that you sit on state boards and foundation boards. Is that the place where our leadership needs to go to help people understand that they haven't been stopped in their efforts, as Tom and John are explaining, by this Supreme Court decision? Is that where we have to go, or do we have to get the community to speak up in some way? And how is the community supposed to speak up about issues that are this technical? They're quite technical for a lay person to try to address and say, you need to do better, by my Central American community in your health training universities. We're not getting a seat at the table. What do you think? What's the proper venue for us to carry this fight forward?
Well, I'm happy to say that the the people that I usually speak to, virtually every member of state government that I speak to, I don't speak to all of them, obviously, but the ones that I speak to are quite proud to be to celebrate diversity. They're quite concerned about under-resourced communities. There's no lack of focus on the benefits of diversity and the historic benefits of affirmative action. Where I see a disconnect is in some of the other sectors. And some of those sectors include higher education institutions. They may include law corporations, law firms that may not be as invested in or may not believe in the value of diversity enough to continue to promote it. These are organizations that can be intimidated by the threat of a lawsuit. Not any of the organizations that I'm personally connected to or aware of, but I know it's happening. I know it's happened. And I think that's really part of the message here, is not the technical illegality that may be subject to a court challenge or court opinion, but the intimidation of a greater number of institutions to basically kind of knuckle under and withdraw their support of diversity. Communities have an important role here. Attorney Saenz mentioned the impact of the Black Lives Matter movement on identifying some of the origins of law enforcement abuse. This is a community movement and just shows how that movement can effectuate change. We need more of that, especially in the face of the psychological warfare that's being waged against diversity at this time.
Tom, let me go back to you and ask, how is this going to impact the undocumented Latino community? Is this going to make it harder for them to access educational opportunities and employment opportunities? Is this going to be used against that population where there's an already some opposition to the movement of populations particularly into California, of people who are undocumented? Is this decision going to hurt that community or those communities as well?
I would say one way that it will hurt those communities is it is already difficult for an undocumented young person to make the decision to apply to college, given that they have obstacles of no work authorization once they graduate. They may face counselors who tell them there's no future for you if you are undocumented. And this is just one more, I think Dr. Carlisle used it correct, it's one more mechanism of psychological warfare that we try to convince certain students, not coincidentally, mainly students of color, that to make their own decision, not to aspire to a Harvard or a UNC, to instead to apply to institutions that are not as selective, or in other circumstances, not to apply to college at all, because it's being built up by those engaged in the psychological warfare as some major obstacle, particularly to students of color. But more broadly, the undocumented population faces today an even higher level of hostility that has been exposed, particularly since 2016 and the election of Donald Trump, of white supremacist, white nationalist thinking when it comes to issues of immigration as well. We had a president of the United States who chose to distinguish those from particular countries, not coincidentally, really diminishing those from countries populated by people of color versus other immigrant source countries. And that it continues to play out. And it's all of a piece with what went on in this case, and particularly what followed it, the threats without real backing to them, without any support in the case to them. But what we are seeing is a resurgence in practice and in how open it is of white supremacist ideology. And that has always played out against immigrants, particularly since mid 20th century, when the majority of those immigrants became first Latino and then Asian added in. So as immigration has become more minoritized, is one way of putting it, we have faced this phenomenon in the immigration arena as well. So to the extent that what's going on with affirmative action is tied to that, and I think there's no question but that it is, that a greater openness about that racist ideology, that will play out in other ways against undocumented immigrants as well. And I say to folks all the time, the America First, American citizens first policies of Donald Trump were very thinly veiled racist, white supremacist ideology.
Well, the newspapers, John Patton, say that Mr. Trump is ahead in the next presidential election. So there seems to be some impetus to support whatever his worldview is among large populations nationally, including those in California, who think Black and brown people have gotten enough. We don't need any more of anything. How are we supposed to rally our forces in light of that situation happening at the very top of our government?
Well, the difficult thing now is to actually have the space to make a free decision on your own. The proliferation of information that is slanted and biased information has caused such a problem, and over politicizing. If we were trying to figure out what was right as opposed to who is right, we might come out with a different conclusion even on that point. I think that Donald Trump represents something, and Thomas said it. He didn't mince his words. There is a concern, and this causes me to have an issue with another term that we use when we talk about minority people. That's like a bean counting exercise, and I'm not sure who's less and who's more. I don't think people of color are minorities. I think people of color are lots of people, and people of goodwill certainly are the majority. And so what I would say is, and that's why I said what I said to you first in the first instance, Sylvia, I think that many people of goodwill are not taking the red meat language that is appealing to make America great again people and actually supremacists. They're concerned that the America they want is going away. And I hope they're right, because it should be. It should not have existed in the first place. This business about America is limited to certain kinds of people for certain kinds of purposes. That was never how we should have seen ourselves. That's not what's written on the Statue of Liberty. And I think that even with this case here, and as we're talking about as lawyers, we're trying to make sure people understand what the legal parameters of the case are and where things stand. But there is a broader question, and that is exactly what you're raising, Sylvia. People don't like the direction things are headed in, and they're doing everything they can to change that direction. But they're running over, in my opinion, the popular sentiments of most people. And I think we have to make sure that things like this happen, places where you can get unfiltered discussion of important matters without being fed a bunch of crap about what it all means and how you get where you're supposed to get. Our university, unique among universities, our university was founded over 50 years ago, and the express mission of the university was to address the racist circumstances that oppressed people in this area. And that's why we were founded. to deal with that. The government wanted us to do that. Everybody wanted us to do that. And so that's what we've been doing for over 50 years. And people like what we're doing. People expect us to continue to do what we're doing. And we are doing what we're doing. And that's the reason why I think it probably is important for us to use the words that we need to use to be accurate about what we're doing and just take on the fight. I hate to say that, but the fight is coming, but I don't think we should run scared because people don't like the word diversity. I don't understand why we would avoid, and one of the Supreme Court justices who actually diversifies the court said, I don't understand what the word means, which is kind of astounding to me. But we'll leave that alone. The point is, when several people of different stripes and backgrounds get together, there is a diversity that is good. When everybody's the same, there's a sameness that may not be good.
Dr. Carlisle, you did a lot of original statistical work during your long tenure at the state level, where you really painted a picture with data of who was here and who was getting what kinds of services. Is that capacity now going to be used against us, where you look at the statistics of a university like UCLA or Yale or CDU and say, statistically, you shouldn't be having that many minorities in your school. What's going on here? We're looking at the facts here, and you've got too many of them in there. What's going on? Is that something that somebody who really is an advocate, maybe not a racist, not somebody who hates undocumented people or hates Latinos, but who just wants a bigger slice of the pie for white America? And they'll look at us and say, well, you got too many of those. By any criteria you're using, you've got too many of those in your school.
Well, that's another really, really interesting and excellent question, Sylvia, very complex. California is now a state with a majority population of peoples of color. So I think that's the benchmark that should apply to any California organization. If you fall below that benchmark, you need to ask yourself why. If you come in above that benchmark, there are probably some reasons for that. In the case of CDU, you could ask the question, well, if you don't use preferences, why are you so diverse? And the answer is because students come to CDU because of who we are, where we are, what we do, and how we do it. We focus on students from South Los Angeles. And that's a pretty diverse community. If we just admit students straight up from South Los Angeles, we'll have dramatic diversity in our enrollment. If we admit students based on the distance that they've traveled socioeconomically in their lives, that results in great diversity in enrollment. If we select students who just want to go back to their communities and make those communities a better place, that promotes diversity. So our students see this, and they recognize, to quote our former provost, the truth in this statement: a house built for you is better than one where you're just a visitor. Students come to CDU because they know that we are a house built for them that celebrates diversity. I asked them, why did you come to CDU when you could have gone to UCLA or Stanford or USC? And they'll say, because your CDU's mission statement attracted me. I'm here because of the mission statement. I can't say that about those other institutions or any other institution. So this is why CDU is able to achieve the diversity, the number 2 ranked diversity in the country, despite having things like racial and ethnic preferences.
Has MALDEF encountered more support or less support, looking at it over the many years that you've been associated with it? You first went there in what year?
93.
93. So here we are in 23, and you were much smaller then. You're bigger now. You're richer now. You've had wonderful leadership, wonderful attorneys, and other staff members. But we had liberal governmental officials afraid of you particularly, even though you seem like such a nice, reasonable person, because you were pressing for fair treatment of particularly the Mexican-American community. And you had to do some hard work to persuade them that what you were trying to do for them, particularly the undocumented Latino community. And that's really kind of surprising that you didn't find more support rather than opposition among liberal elected leaders. Are we past that now? Are we, where are we?
We still have issues, even with progressive leaders. I have been perhaps in some folks' views too outspoken about the Biden administration's judicial nominations, mainly because they do not include the Latino community at rates that would be expected given longstanding exclusion. And of course, there are folks who don't like that. And that's because they view the world so politically polarized that you don't ever criticize our side, quote unquote. But of course, that's not the role of a nonprofit. Our role is to criticize folks, regardless of their ideology, who are in authority and making, in our view, poor decisions. Now, I do think that, as John said, the problem that we're facing today is not a problem of the majority of people in this country, not by a long shot. We somehow have allowed a relatively small percentage of the population through aggressive outspokenness to somehow appear to be larger than they are. That's not accounting for the polls that you cited earlier about likely outcomes in 2024. I expect that will change dramatically just as time goes by and we get closer to the prospect of another Trump administration. Mm-hmm. But the fact is that the numbers are in favor of greater inclusion. They're in favor of greater diversity. They're in favor of greater equity. And I think that we have to take advantage of that underlying strong majority support for what are baseline principles. Now, in the early part of our nation's history, those principles were really honored more in the violation than in compliance with them. But notions like equity, like inclusion, are baseline principles for this country, and we have to explain how that plays out in what we are talking about. And one thing I will say is we were somewhat constrained since 1978 because the Bakke decision, which is the 45-year-old decision that this Supreme Court has now basically overruled, the second longstanding precedent overruled in 2 years. A year ago, they overruled the 49-year-old precedent in Roe versus Wade, and this year they effectively overruled the 45-year-old precedent in Bakke versus UC Regents, which upheld the limited consideration of race in making admissions decisions. But one other outcome of that case was that Justice Powell, who ended up deciding what the law was because the other 8 justices were evenly split 4-4, so he got to decide what the law was, and he said at that time in 1978, diversity is the only government interest that can support consideration of race in admissions. And he specifically rejected, quote unquote societal discrimination as a basis to consider race in making admissions decisions. And I've always bristled that meant that we were talking about diversity and diversity alone. And diversity is incredibly important. But what it put on the back burner was discussion of equity. Mm-hmm. Equity, in my view, has an even stronger foundation in the basic principles of this country. It simply should not be the case, that Latinos are 60+% of high school students in California, but are represented at UC Berkeley at less than half that, less than 30%. That's an inequity that we all should question. And I will say that historically, going back to the civil rights era, there has been a presumptive pathology about significant racial disparities. If you see that much of a disparity, it means there's a problem, and we have to look at the problem and try to solve the problem. At bottom, what I think these forces that brought these cases to the Supreme Court, that are now trying to misinterpret them to apply them more broadly, at bottom, what they are at is trying to convince us to abandon the presumptive illegitimacy, the presumptive pathology of significant racial disparity. They want all of us, when we hear about those huge disparities, to say, oh, well, that's expected. That's the way it works in a free society. People choose what they choose. And that's just not accurate. Not accurate at all. I can guarantee you that Latinos don't choose to be represented at half their proportion at UC Berkeley in comparison to high school. Nobody chooses to be overrepresented in positions of little power and underrepresented in positions of power. So we have to continue to recognize that significant racial disparity is presumptively illegitimate. That means it's something we have to talk about. We have to seek to remedy in this country.
Well, I hope you will come to CDU and talk about just that issue to our students, based on the deep and rich experience that you've had fighting these issues over the years with friend and foe, not just with foe. I mean, I was struck looking at your background at how frequently people who you would think would automatically be on your side weren't on your side, and you really had to work to get them to recognize what was at stake. Let me ask one last question to Mr. Patton. You've raised amazing points about unfiltered conversations that are needed to happen to address the real issues. How does the new MD program do this and work toward this? How can we work that into not just how do you do a cadaver examination, but how do you do a cadaver examination on the issues that Tom is talking about us being against, and make them be our ambassadors to these diverse communities that they represent, going out as really leaders of working better together?
There's an ironic duality going on here. Some people are deciding what can be taught in elementary schools that is legitimate history of this country. Everybody knows it. You can see what Tom said. I would almost rest on his statement. When you look at the circumstances, you can see what the problem is. The reason why we call it affirmative action is because without some kind of overt action, these problems are not going to solve themselves. That's the only reason why we call it affirmative action, because after 400 years, it looks like, even before there was a United States, it looks like the circumstances that have been woven into the fabric of this nation aren't going to unweave themselves and suddenly become just. So somebody has to do something affirmatively to solve that problem. Now, if the shoe was on the other foot and they were me, they'd see it perfectly. Because where I'm sitting, I don't know how they drive down the street and cops walk up to them after they're speeding with hands on guns. Maybe that happens to them too. But affirmative action only means we're going to do something that's a little bit different than what's been going on, because it's not going to change by itself. People in power like power. People who are underneath power don't like it. It's not like we want to be underneath the power, but what we have to do is begin to develop the places where we can have this conversation. Revolutions, and again, another term, I don't mean to start being controversial. Revolutions never start from the top down. They always start from the bottom up. Because the people who are oppressed, who are not the minority, finally decide we're not going to take it anymore. That's what happened in South Africa. I don't care what you have. We have truth and justice on our side, and we have people on our side, and we're going to fight until either we're all dead or we're all free. And America will probably get to that place too. They'll have to kill all of us, and then they can make America great again, whatever that means to them, because they'll have killed all of us. If they don't kill all of us, we're going to continue to speak truth to power. That's our job. And at this university, we're treating and we're teaching whole people. In our medical school class, we want them not to just be doctors, but leaders. We want them to be articulate and speak what they believe is right. And don't be afraid because other people are well organized or well financed. They're not going to win. We just we can't give up. If we quit, that's how they win. If we don't quit, we win. The moral imperative is on our side.
Dr. Carlisle, let me give you the last word. That was wonderful.
Well, I think the last word is actually what we just heard from General Counsel Patton. I don't know if I could state it more emphatically and eloquently than he just did. I will say this is not the end of an issue, it's the beginning. And we still have a long way to go. This is not a fight that's over. And the terms social justice and health equity, for example, still resonate among the people and communities that I think are important. And that's where we need to be.
Right. Well, let me thank the three of you so much for this conversation, which obviously needs to go on longer and happen more frequently. It's very helpful to hear people of the accomplishments of the three of you working on it, trying to lead young people to a better place tomorrow. So I compliment you all and thank you for your time and sharing your experiences with us today. Thank you, participants, for being here. We'll see you next time.